In today's digital age, data is the lifeblood of businesses, but with this reliance comes great responsibility. The General Data Protection Regulation, or GDPR, stands as a landmark legislation, reshaping how organizations worldwide manage and protect personal data. We will delve into the intricacies of GDPR, exploring its impact, principles, and the rights of individuals. The GDPR, implemented in May 2018, represents a comprehensive overhaul of data protection laws within the European Union. Its reach extends far beyond the EU's borders, impacting any organization handling personal data of EU residents, regardless of their geographical location. This regulation is not merely a set of rules, but a fundamental shift in how we perceive and manage data privacy. The significance of GDPR lies in its recognition of privacy as a fundamental human right, demanding a higher standard of data protection and accountability from organizations. This regulation's impact is undeniable. It has empowered individuals with greater control over their personal information, compelling businesses to rethink their data processing practices. The GDPR emphasizes transparency and fairness, requiring organizations to be clear about how they collect, use, and store data. This shift towards a more privacy-conscious approach is not just about compliance, it's about building trust and fostering stronger relationships with customers. The GDPR's influence extends beyond the EU, inspiring similar data protection regulations globally. Countries worldwide are enacting or revising their privacy laws, drawing inspiration from the GDPR's principles and framework. This global trend underscores the growing awareness and importance of data privacy in the digital age. It signifies a move towards a future where individuals have more control and transparency over their personal information, regardless of where they reside or which companies they interact with. At its core, GDPR rests on 7 key principles: lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitations, integrity and confidentiality, and accountability. Each principle plays a crucial role in shaping responsible data handling practices. The principle of lawfulness mandates that all processing of personal data must have a legitimate legal basis, clearly defined and communicated to the data subject. Fairness emphasizes that data processing should be reasonable, equitable, and not unduly disadvantageous to individuals. Transparency, a cornerstone of GDPR, compels organizations to be open and honest about their data processing activities. This includes providing clear, concise, and easily accessible information to individuals about how their data is collected, used, and stored. Purpose limitation restricts data processing to the specific, explicit, and legitimate purposes for which it was initially collected. Organizations must clearly define these purposes and avoid using personal data for any unrelated or incompatible purposes without obtaining explicit consent. Data minimization mandates that organizations should only collect and process the minimum amount of personal data necessary for the specified purpose. This principle encourages efficient data management practices and minimizes the risks associated with holding excessive or irrelevant information. Accuracy ensures that personal data held is accurate and, where necessary, kept up to date. Organizations are responsible for implementing mechanisms to rectify or erase inaccurate data promptly, ensuring that individuals' rights are protected and decisions made based on this data are fair and reliable. GDPR empowers individuals with a comprehensive set of rights concerning their personal data. These rights are central to the regulation's ethos of placing individuals in control of their information. The right to access grants individuals the ability to obtain confirmation from organizations about whether their personal data is being processed, and, if so, to access that data and receive relevant information about its processing. The right to rectification allows individuals to have inaccurate personal data corrected, ensuring that the information held about them is accurate and up to date. The right to erasure, often referred to as the right to be forgotten, empowers individuals to request the deletion of their personal data under certain circumstances. These circumstances include situations where the data is no longer necessary for the original purpose, consent has been withdrawn, or the data has been unlawfully processed. The right to restriction of processing allows individuals to request limitations on the processing of their personal data in specific situations. This right applies when the accuracy of the data is contested, processing is unlawful, or the individual objects to processing based on legitimate interests. The right to data portability grants individuals the ability to receive their personal data, which they have provided to a controller, in a structured, commonly used and machine-readable format. It also enables them to transmit this data to another controller without hindrance, fostering data mobility and empowering individuals to switch service providers more easily. Organizational responsibilities, a paradigm shift in data processing. The General Data Protection Regulation, or GDPR, places significant responsibilities on organizations that process personal data, demanding a paradigm shift in how data is collected, handled, and protected. Organizations are obligated to implement appropriate technical and organizational measures to ensure and demonstrate compliance with the regulation's principles. This includes conducting data protection impact assessments, or DPIAs, when processing activities involve high-risk data processing, documenting data processing activities, and adhering to the principles of data protection by design and default. Organizations must appoint a data protection officer, or DPO, if their core activities involve regular and systematic monitoring of data subjects on a large scale or processing special categories of personal data. Organizations are obligated to respond to data subject requests promptly and effectively. This includes requests to exercise their rights to access, rectification, erasure, restriction of processing, and data portability. Failure to comply with these requests within the stipulated timeframe can result in regulatory action and penalties. International data transfers, navigating cross-border challenges. GDPR places strict rules on transferring personal data outside the European Economic Area. Organizations must ensure that any transfer of personal data outside the EEA is subject to appropriate safeguards, ensuring the protection of individuals' rights and freedoms. The European Commission can recognize a third country as providing an adequate level of data protection, equivalent to that of the GDPR. Data transfers to these countries can occur without requiring any further authorization. It's crucial for organizations to stay informed about the evolving landscape of international data transfer mechanisms. The European Commission regularly reviews and updates adequacy decisions, SCCs, and other mechanisms to ensure ongoing protection for personal data transferred outside the EEA. GDPR empowers supervisory authorities to impose significant penalties on organizations that fail to comply with its provisions. These penalties can be substantial, reaching up to €20 million, or 4% of the company's global annual turnover, whichever is higher. The implications of non-compliance extend beyond financial penalties. Organizations may face reputational damage, legal challenges from data subjects, and a loss of customer trust, which can significantly impact their bottom line and long-term sustainability. It is important to note that the goal of GDPR is not to punish organizations, but to foster a culture of data protection and accountability. For more information on how you can manage your privacy data, get in touch with one of our customer service team.